My name is Severina Magill. I teach at Jindal Global Law School, and this module is for the ePathshala UGC. The aim of this module is for the reader to identify major reproductive issues in India from a women's rights perspective. It also engages the reader with the key provisions of existing laws, regulations and schemes with regard to different reproductive rights issues. Finally, it helps in acquiring knowledge of and understanding major judgments by the Indian courts in the field of reproductive rights. In 2015, the final year for achieving the targets set in the UN Millennium Development Goals, or MDGs for short, India accounted for 45,000 maternal deaths. This was second only to Nigeria. Though India's maternal mortality rate, or MMR, has decreased over the years, today 5 women still die every hour from largely preventable causes. Causes that contribute to preventable deaths can be attributed to nutrition, a lack of public healthcare infrastructure, for example institutional deliveries and obstetric care, and unhygienic conditions in hospitals. While maternal mortality is one of the primary developmental concerns in India, reproductive rights issues are not limited to the prevention of maternal deaths and securing a right to survive pregnancy. Beyond maternal death, India's healthcare system and public healthcare officials routinely deny women control over their bodies. Since the year 2010, India has witnessed numerous scandals involving mass hysterectomies and forced sterilizations through coercive measures. Active control over reproductive choices is denied to women across the country through restrictive abortion laws, barriers to accessing contraceptives, as well as the prevalence of female sterilization, child marriage, and a lack of effective maternity leave for women in the informal sectors. The Cairo Conference on International Population and Development, hereinafter the ICPD, in 1994, issued a comprehensive definition of reproductive rights. This module will be relying upon this definition. It states, reproductive rights rest on the recognition of the basic right of all couples and individuals to decide freely and responsibly the number, spacing, and timing of their children, and to have the information and means to do so, and the right to attain the highest available standard of sexual and reproductive health. They also include the right of all to make decisions concerning reproduction free from discrimination, coercion, and violence. This definition of reproductive rights places the emphasis on women's capacity alone or with her partner to make reproductive choices. In doing so, it also emphasizes the role that law can and has played to enable women's reproductive autonomy as a right. The role of law in this area of reproductive rights becomes evident when we consider the plethora of judgments and legal actions exercised by women to claim their rights from the state or to seek redress for alleged violations. Law has led the Supreme Court of India to hold that the right to life and personal liberty under Article 21 of the Constitution contained reproductive rights as part of the concept of personal liberty, the right to health, as well as the right to dignity. This module will focus on 2 areas that constitute major reproductive rights issues in India, and where judgments by the courts have made progress with regard to the ability of women to actively make reproductive choices. Section 1 will focus on population control and sterilization in India. The participant will learn about the Supreme Court's guidelines regarding sterilization, indemnity schemes for women having undergone a sterilization procedure, as well as a brief historical background of sterilization policies in India. Section 2 will focus on an area that is closely related to population control, access to contraceptives. Here, we will identify current trends in contraceptive use in India through the National Family Planning Health Survey, and we will examine India's policy regarding access to contraceptive services from a rights-based perspective. This section gives a brief overview of the history of population control in India before examining judgments by the Supreme Court of India regarding sterilizations. The section will also give an overview of the Family Planning Indemnity Scheme. A brief history of family planning and sterilization policies is explained hereinafter. India was the first country in the world to have an official policy on family planning. The first 5-year plan in 1952 was aimed at improving maternal and child health, and over time became centred on demographic control and bringing down birth rates. Whilst initially the policy did not create any targets, it was during the emergency period of 1975 to 1976 that the first target figures were introduced into the national planning policy. The same policy also allowed state legislatures to pass laws requiring compulsory sterilizations. As a result, an estimated 8 million people were forcibly sterilized in this period from 1967 to 1977. This led to a backlash against the government, who was forced to assure the public that these programs were voluntary. The target-based approach was abandoned in favour of a rights-based approach during the 1990s as a result of the Cairo International Conference on Population and Development and the Beijing Women's Conference and Programme for Action, to which India is a state signatory. Despite the change in official policy on the ground, targets are still a reality, and public health officials and state governments implicitly still favour sterilizations over other forms of birth control. During the National Family Health Survey No. 3, 84% of women were sterilised in a government hospital, while most forms of contraceptive methods to regulate the spacing and number of children were given by private sector hospitals. There are numerous case laws on the sterilisation procedures. Unhygienic conditions during medical interventions such as sterilisation has led to the preventable deaths of many women. This led the Supreme Court in 2003 to pass guidelines regarding sterilisation as part of the judgment in the Ramakant Rai v. Union of India case. In this case, the facts brought to the notice of the court indicated that public health officials in government-run sterilisation centres across India failed to treat women in a dignified way. Officials in these centres failed to counsel women on other forms of birth control, and women were often coerced into undergoing a tubectomy through false promises and monetary incentives. Moreover, the findings of the petitioners showed that a lack of hygiene in sterilisation centres had led to the infections and deaths of women after treatment. The Supreme Court held that state governments before and while conducting sterilisation procedures must: Number 1, introduce a system of empanelled doctors with at least 5 years of gynecological training who are allowed to perform sterilisation procedures. Number 2, circulate a checklist among doctors containing, at the very least, the age, health and number of children of the patient. 3, consent pro formas. 4, institute quality assurance committees. And 5, maintain a statistical record. 6, lead an inquiry into every breach of the guidelines and enact an insurance policy until the centre prescribes a uniform format for all states. Despite these guidelines, sterilizations were carried out across India in blatant disregard of the order of the Apex Court. In Devaka Biswas versus the Union of India, 9 years after the Supreme Court issued guidelines in Ramakant Rai, the ground realities for poor and marginalised women remain the same. In this case, sterilizations were carried out at night under torchlight in a government middle school in Bihar by untrained NGO volunteers. The facts of the Devaka Biswas case highlight a blatant disregard by state governments for the sterilisation guidelines and the Supreme Court order. It also demonstrates a disregard for the fact that each state government and the centre should ensure that no targets exist with regard to family planning policies. State governments should discontinue sterilisation camps at the earliest, and in any case within 3 years. They should also strengthen primary healthcare infrastructure. Both the Ramakant Rai and Devaka Biswas cases have made extensive use of Indian constitutional law, especially Articles 14, 15, 21 and 51 of the Constitution, and of other judgments that the Supreme Court has given on the right to health. These articles guarantee the right to equality, prohibit discrimination on the basis of sex and other statuses, and provide for substantive equality, protects the right to life and personal liberty, and obligates the state to protect, respect international law. Article 21 of the Constitution is certainly the most important article, as it protects the right to life, personal liberty, and dignity of the individual. The right to life, in conjunction with Article 14, is at the centre of both cases with the Supreme Court. With regard to the right to health of women, the Court recalled its decision of Bandhua Mukti Morcha, where it was held that the obligation of the state to ensure the fundamental rights of weaker sections of society are not exploited owing to their position in society. By invoking Article 21, together with Article 51 of the Constitution, which provides that the state shall foster respect for international law and treaty obligations, the Supreme Court was able to interpret the right to life and personal liberty in light of recommendations of treaty bodies and of international court decisions. In Devika Biswas, for example, the Apex Court relied on the recommendations made by the CEDAW Committee in the case of AS versus Hungary to hold that the time given to women to consider their decision to undergo a sterilisation procedure was insufficient, and that the idea of targets and incentives for doctors are incompatible with the idea of free and informed consent. The following section will put forth the government schemes in existence. The Family Planning Indemnity Scheme, like its precursor, the National Population Policy from 2000, aims to improve the quality of services with regard to family planning. The scheme incorporates the guidelines laid down by the Supreme Court in Ramakant Rai, and its main purpose is to compensate women who undergo sterilisation procedures, as well as doctors, in public and private healthcare institutions. The methodology followed by the scheme is to divide states into high focus and non-high focus states, and fix compensation rates according to the type of procedure and the nature of the state, high or non-high focus states. Compensation for death following a sterilisation is also categorised into two categories, depending on the time passed between the sterilisation and the death. 1 lakh rupees for death following the procedure should be given, and 30,000 rupees for death within 8 to 30 days of the procedure should be given, or 20,000 rupees each for the failure of or complication arising from a sterilisation. Compliance with the scheme is monitored by the central and state monitoring committees on a monthly and quarterly basis. A state nodal officer of the State Ministry of Health is charged with reviewing all pending matters regarding pending claims. The scheme is monitored by a national nodal officer who reviews matters relating to the scheme on a half-yearly basis. The Family Planning Indemnity Scheme has, however, been criticised for a number of reasons, and fact-finding committees by civil society organisations have shown that there is a gap between the theoretical setup of the scheme and its actual implementation. In practice, sterilisations have been denied to women who have only had girls, and public health officials deem a family complete only if at least one child is a boy. As a result, the choice of the woman is disregarded, and the use of post-placental intrauterine contraceptive devices is recommended. This section will first examine statistics and schemes on access to contraception before detailing rules and regulations regarding access to contraception. Access to contraception methods is closely linked to the problem of coercive sterilisation policies. In order to fully make use of their right to reproductive choices, access to contraception, information about different types of contraception, and related medical care must be available to women. The National Family Health Survey No. 3 shows that the policies of the Indian government are ineffective, as only 56% of married women in the age group of 15 to 49 years currently use any form of contraception. The National Family Health Survey No. 4 indicates that over a period of time of 10 years, the percentage of married women in the same age group who use contraception has decreased by 3.2%. Sterilizations are by far the most common form of contraception, and over a 10-year period from NFHS3 to NFHS4, marginal decreases of 1.3% for female sterilizations and 0.7% for male sterilizations have taken place. Condom and contraceptive pill usage have also made small increments. This decrease in contraceptive use is occurring despite modern contraceptive methods being listed in the National List of Essential Medicines. This lists those medicines that the National Rural Health Mission has to have in stock. Moreover, contraception and counselling on the various types available to women is an integral part of the National Rural Health Scheme, which provides 2 schemes that women can avail of: delivery of contraceptives by an ASHA worker at the doorstep, or utilising services of ASHAs for ensuring spacing in birth. Research and fact-finding by civil society has shown, however, that the quality of government contraceptive services is poor, and that women have limited access to contraceptive information and education. This results in serious misconceptions about contraception and deprives women of the ability to make fully informed decisions about their reproductive health care and contraceptive methods. Legal actions to improve access to contraceptives by civil society have been met with reluctance by the courts. The Punjab High Court in Himat Mahila Samuh versus the Union of India refused to issue an order stating that the various steps taken by the government were sufficient since the fertility rate had decreased over the years. This order came despite evidence to the contrary by the petitioners. Among many things, the fact-finding conducted by the petitioners revealed that the state of Haryana had emphasised sterilizations over contraception, and that access to contraceptive methods and services was of poor quality and of limited availability. For example, the study showed that only 2 out of 91 pharmacies, 2%, had stocked diaphragms and female condoms in the past, and that ASHA workers were insufficiently trained, with 5 out of 17 interviewees indicating that they had not received training on contraceptive methods. Moreover, the finding of the court is inconsistent with recent statistical data that shows that contraceptive use among married women in the age group of 15 to 49 years has only marginally increased. Further, the lack of contraceptive access has been repeatedly criticised by international bodies such as the CEDAW Committee. The committee in this regard has noted that during the consideration of India's 5th and 6th periodic report, it is concerned about the limited availability and accessibility of modern forms of contraception, including emergency contraception to prevent unplanned pregnancies, the lack of information and education on reproductive sexual health, and problems for women in trying to access contraceptives has resulted in a panoply of undesirable public health outcomes. First of all, barriers in accessing contraceptives, as well as the non-use of male condoms, results in a high use of emergency contraceptive pills among unmarried women who are sexually active. Emergency contraception is not intended to be used in lieu of regular contraceptive methods and, unlike male condoms, do not protect the user from sexually transmitted infections. Secondly, inability to access contraceptive methods results in higher abortion figures and, importantly, higher unsafe abortions. India's legal framework and public health policy regarding medical abortions will be discussed in a separate module. This section concludes the module and states that reproductive rights that empower women by giving them control over their bodies and the ability to make informed choices are today much clearer than at the beginning of reproductive rights litigation and advocacy in the early 2000s. Judicial interventions and advocacy efforts have led courts and the government alike to a certain extent to enforce fundamental rights that dignify women, amend existing policies as can be seen through the 2 issues examined above. However, there's a lot of ground that remains to be covered, as can be seen from Section 2 of this module, and ensuring that women have better access to contraceptive methods and birth control remains as important as ever. Barriers in the access to contraception are twofold, and only the legal side of the issues has been explored here. Another barrier is societal acceptance of female contraceptive use, a view that necessarily needs to be changed as much as the legal framework. This needs to happen to ensure that women are able to enjoy the full spectrum of rights inherent to and afforded to them by the Indian Constitution and international human rights law. Without such legal and social changes happening together, inability to access contraceptives and obstacles in terms of learning about how to use them and best practice will remain sporadic and few and far between. This module has tried to examine two significant areas of women's reproductive rights: freedom from coerced sterilizations and information and access to effective forms of contraception, both to prevent unplanned pregnancies and to space and regulate the timing of children, but also to prevent the transmission of sexually transmitted infections. Only when both of these become a reality for women across India and in all socio-economic groups will women's reproductive rights go further in terms of upholding their right to life with dignity and freedom from discrimination based on their sex and socio-economic status. This module is now complete. Thank you.